The broadcast is now starting. All attendees are in listen-only mode.
Hi, welcome everyone. This is Marlis Carson from NCFC. I want to thank everybody for joining the webinar. We're a few minutes late here due to some technical issues, but we're ready to get underway. A couple of housekeeping items before we get started. We have quite a few attendees on the line, so all the attendees will be muted. But if you'd like to ask a question, you can type it in the questions box on your control panel, and we will provide as many questions as time allows to the presenters during the Q&A portion of the webinar. So with that, I'll turn it over to Chuck Connor to say a few words. Chuck?
Well, thank you, Marlis, and I also want to join her in extending my welcome to all of you who have joined. Even though the people that are having difficulties with all the technical difficulties may not be on, I do apologize for that. And obviously this is, we're just overloaded with information here, but we will hopefully work through those glitches and make sure that this information that we get today will be shared with everyone. Most of you know that we have been putting out a tremendous amount of material in the last 3 weeks relevant to COVID-19 and all of its implications, but as well then, particularly since last week, putting out a lot of information relative to the $350 billion that was provided by Congress to be distributed to through the Small Business Administration. And again, I suspect we have put out probably close to 10 to 15 notices through our government affairs channel, and including others on that. And so our government affairs specialists have been communicating extensively on this, and a lot of information has been shared. But I thought it would be helpful to take it in a little bit of a different avenue and employ some of the resources within not our government affairs, but our legal, tax, and accounting committee, which includes our lawyers and more of the financial people, to share some information and to have a discussion among that group as well, and bring in some of our sort of noted legal minds, and as they will say to you many times, not to provide you legal advice. Certainly, you need to do that for yourself, but to certainly have a discussion more along the legal side than perhaps what we have had up to this point, now that the money has been approved and sign up for the loans is open. And so I hope this discussion among more of the legal side is helpful to you. And again, we will follow up with each one of you to make sure that all of your questions are answered, and that we make sure that agriculture in general, but co-ops in particular, are getting access to their fair share, if you will. And I'm not sure that's the right expression, but certainly to our share of the money that is out there that is going to be distributed. It's going to be messy, but the money will get out the door, and we just need to make sure that we're there and doing what we need to do in representing our farmer owners. So again, thank you all for joining, and I look forward to hearing the presentations myself.
Thank you, Chuck. As Chuck said, we're fortunate to have several folks who have agreed to speak on very short notice here on this program. Taking the lead with the PowerPoint presentation are Jeff Scheer and Levi Smith. Jeff is an attorney with Bond, Schoeneck King in Syracuse. Mr. Scheer represents a wide range of small to mid-sized businesses across New York State. Levi Smith is an attorney with Fredrikson Byron in Minneapolis. Levi advises banks and other lending institutions on a variety of loan transactions and has significant experience leading all types of loan transactions. Following Levi and Jeff, we will hear from Brian Cavey, Senior Vice President of Government Affairs at CoBank. And also on hand to help us answer questions are several LTA committee members, Dan Mott with Fredrikson Byron, Charlie Sullivan with Bond, Schoeneck King, and Dave Swanson and Ken Logsdon with Dorsey. They're going to help answer any questions that you send in using the questions feature on your screen. So with that, I'll turn it over to Levi Smith to begin our PowerPoint presentation.
All right, thanks so much, Marlis, and thanks for inviting me here today to talk, and welcome everyone who's listening in. So today we're going to talk about mostly focused on the Paycheck Protection Program that was part of the CARES Act passed a couple of weeks ago at this point. As a starting point, I just wanted to say, as some of you may have experienced, there are some unanswered questions associated with this program. It seems like information is changing pretty often, and something that we thought was maybe the way things were a day ago seems to be different as new guidance comes out, and something that we know today here on the program may change in an hour or tomorrow. So with that, I just wanted to say that we'll do our best to answer questions. But of course, if there's a particular situation applicable to your particular facts, we'd ask you to check with your legal advisors and your other advisors about how something may be applicable to your circumstances. And just note that we're not acting as lawyers in this particular context. So you should check with your own legal advisors on any particular questions. With that kind of disclaimer out of the way, we can get started in talking about the program. I'm just going to advance here to the next slide. All right, so as I mentioned in the beginning, we're going to talk about mostly the Paycheck Protection Program and the various eligibility, application, and loan forgiveness aspects of that program. We will touch briefly on a couple of other programs that are available that were also rolled out either in connection with the CARES Act or in connection with the COVID-19 crisis. Those include the Economic Injury Disaster Loan Program, which is an existing SBA program, and then also we'll touch briefly on some tax credit opportunities that are available under the CARES Act as well. Go one more slide here. All right, so for an overview of the Paycheck Protection Program, which as we all know has been in the news quite a bit these days, it is a $349 billion program of total funds available. The funds will be distributed on a first come, first served basis. And we know that there isn't going to be unlimited money. So applicants are encouraged to get their applications in as soon as possible. The program is available for smaller businesses, those with 500 or fewer employees, with certain exceptions to that rule, which we will touch on, as well as sole proprietors, independent contractors, and self-employed folks are also generally eligible. Certain nonprofits are also eligible for loans under the Paycheck Protection Program, though it only covers 501c3s and 501c19s, and including some tribal business concerns as well. Bear with us on the slide advance. All right, so the Paycheck Protection Program loans are administered by the Small Business Administration through a loan program established by them. This loan program looks a lot like the existing 7A SBA loan program, if folks are familiar with that. And a lot of the 7A lenders are participating in this program, though it has been open to other banks, including banks in the Farm Credit System, as we'll talk about later. The applications opened on Friday, April 3rd, for small businesses and sole proprietorships. And then starting on April 10th, independent contractors and self-employed individuals can apply. Some of you may have seen that there's an application form on Treasury's website currently, and we understand that a lot of banks are using that form, as well as using some other forms to gather additional information. One important point here is that a borrower can only get one paycheck protection loan, and there's a certification on the application that the borrower has not received another loan under this program. The purpose of the paycheck, excuse me, so if we went ahead too many. The purpose of the Paycheck Protection Program is to assist small businesses with efforts to retain employees and maintain payroll in these trying economic times. The overall loan cap is at $10 million per applicant or per borrower, and it may be less than that. The formula is based on that the loan amount will be equal to 2.5 times the average monthly payroll cost of the borrower for the prior year. One question that we've been getting a lot of is exactly what is payroll and what are payroll costs? This slide has a lot of information on it, but I think it may be helpful to spend some time on it because there are things that are explicitly included under the statute or under some guidance that we've gotten from SBA. And then there's some other items that aren't included. And then there are some items that aren't specified, and you sort of have to look at the circumstances to see if we think they qualify. So payroll costs that are included, which are compensation to employees. Now, note that the employees, their principal place of residence has to be in the United States. If their principal place of residence is outside of the United States, that compensation cannot count for purposes of determining the loan amount as the multiplication of payroll. And this compensation is in the form of salary, wages, commissions, or other similar compensation, cash tips, or the equivalent. And the tips or the equivalent can be based on employer records or a good faith estimate if the employer doesn't have those records. Also covered under payroll costs are payments for vacation, parental, family, medical, or other sick leave, an allowance for separation or dismissal costs, payment for the provision of employee benefits consisting of group healthcare coverage, and this includes insurance premiums and retirement benefits, as well as the payment of certain state and local taxes based on the compensation of employees. There are, of course, things that aren't in this particular listing, and for those, you'll really have to look at your own set of circumstances to determine if what you're trying to get covered actually meets the criteria for this loan. We can chat more about those if there are particulars in the questions section of the presentation. One note here for independent contractors, if there's any independent contractors thinking about applying for these loans, that payroll for independent contractors includes wages, commissions, income, or net earnings from self-employment or other similar compensation. So it's along the same lines of what was talked about on the previous slide. And the way I've been thinking about it is if the purpose of the loan program is to allow businesses to continue to make payroll so that employees continue to have a paycheck to get through these challenging times, it's those types of things that I think will be permitted to be paid with these various loan proceeds. Here's a little bit of a summary on things that are excluded from payroll. As I mentioned earlier, compensation of an employee whose principal place of business or residence is outside of the United States is excluded. There is a $100,000 cap on individual employee compensation, such that if you have an employee who earns over than $100,000, the excess above $100,000 cannot be included in the amount of payroll that's calculated for purposes of determining the loan amount, which again is based on that 2.5 times multiplier of the prior year's average monthly payroll. Certain employment taxes imposed or withheld between February 15th of this year and June 30th of this year are not included in payroll, and qualified sick and family leave wages for which a company is otherwise getting a credit under the CARES Act are not permitted to be counted as payroll under the Payroll Protection Program. One important point here, just to touch on an issue of eligibility. So companies that are eligible have to have 500 or fewer employees, although it is subject to certain exceptions, and we can talk about those. But one note here is that if your business has independent contractors, those contractors do not count as employees for purposes of the loan calculations. And this is because independent contractors have the ability to apply for these loans on their own, as we previously discussed. I might just touch briefly on the issue of 500 employees because it has been a topic that we've been getting quite a bit. The general rule is that a business has to have 500 or fewer employees, or the number of employees that the SBA has determined for the business to be eligible for other SBA loans, and you take the greater of that number. So for some companies, if they look at what SBA has determined for their industry, that amount could be 1,000 or 1,200 employees. For those particular companies in those particular industries, they would use the greater of 500 or the amount that SBA has otherwise determined. And there has been a lot of discussion about these affiliation rules, as some of you may have heard, with certain limited exceptions. the existing SBA affiliation rules are in place, such that, as generally speaking, if you're a company who controls or is under common control with other companies, their employees will be aggregated with your employees for purposes of calculating whether you have 500 or fewer employees. I suspect we may get some questions on that particular item, and we can talk about that later. Circling back to what the loan proceeds can actually be used for, again, because the purpose of this program is to maintain employee salaries are one of the main items that are permitted uses, in addition to vacation, parental, family, medical, or sick leave, group healthcare and retirement benefits, income withholding taxes, as we discussed before, and also loan proceeds can be used to pay mortgage interest payments, rent payments, and utility payments. Those are all permitted uses for the payroll protection loan proceeds, in addition to the employee salaries and other employee benefits type of uses. The loan terms are the same for everyone across the country. The interest rate is 1%. The term is 2 years. There is no collateral needed, and there are no personal guarantees required. For the loan qualifications, in addition to meeting the other eligibility criteria, the business has to have been in operation since February 15 of 2020. It has to have paid salaries, payroll taxes, or Form 1099 non-employee compensation, again, with the focus being on compensating businesses to be able to make payroll. And then it has to meet these certain size limitations, again, the 500 or fewer employees with the exceptions I mentioned before. And then here's just another note that the affiliation rules still apply. I'm now going to turn it over to Jeff to talk about the loan application and some of the forgiveness aspects of the program.
Thanks, Levi. It's good to talk to everybody. And just to kind of comment on what Levi mentioned, we're consistently or constantly seeing changes in the law and explanations as to what was originally written. So we're going to go through as best we can now, and with the understanding that may all change in an hour or tomorrow. So first is to talk about the loan application. We talked about this a little bit earlier. The applications have to be in before June 30th. But right now, with some guidance that came out last week, it's clear that the loans are on a first come, first served basis. So we're seeing a lot of applicants, attempt to get their applications in as quickly as possible. As far as I know, most banks are kind of up and running and accepting applications right now. There are some banks that are a little slow, but for the most part, the applications are ready. As Levi said, they're available online. If you were to go to sba.gov and probably follow the links, you'll find the application. Some banks are using their own process online. They have a portal set up, so that would be the first place to look if you're interested in applying for the loan. As we're going to talk through here, a business that obtains one of these Paycheck Protection loans will be ineligible for certain other benefits under the Act, specifically the Employee Retention Tax Credit, which I'll mention kind of at the end of this talk, and you can only get one Paycheck Protection loan. So then we go to the next slide here. All right, I'm going to keep talking while we go to the next slide because I can't move. There we go. All right, so one of the big aspects of this, the Paycheck Protection Loan Program, is the forgiveness aspect. And the way that I've really described this to a lot of my clients and a lot of people I've been talking to is that this is really essentially a government grant. It's a grant from the federal government, but they want to make sure that the monies are used for the intended purpose, which is really to hire back your employees or keep your employees working. And at the end of a period, so long as you use the money for the intended purpose, most, but maybe all, would get forgiven through this program. So the idea is that there's a forgiveness period that's measured starting on the day that you receive the loan and for an 8-week period. That's called a covered period. And During that period, the funds should be utilized, as Levi said, to make payroll costs, a payment of interest on mortgage, rent obligations, and utilities. The idea and the rule of thumb is on this that not more than 25% of the loan forgiveness amount can be attributable to non-payroll costs. So really looking at that the other way is that at least 75%, if not more, of the loan that you receive should be used for payroll costs. And Levi went through the aspects of payroll costs a little bit earlier here. So we'll go to the next slide here. So to qualify for the forgiveness, the lender is going to require detailed supporting documentation. And if you look at the statute, or if you read any of the materials that are out there, there's a certification that the borrower has to provide. It basically says, you know, the economic uncertainty that we have is supporting my request for the loan, that I've incurred these expenses during the 8-week period. I've used the fund to retain employees. And you really have to make that certification to be able to qualify for the forgiveness. And, you know, the lenders are in a position where they can deny the forgiveness if that required documentation is not submitted. So one of the things that, you know, I've been talking with clients about is, you know, the monies that are received, make sure you can account for them. If necessary, put them into a separate account. Make sure you know exactly how those monies are received. So at the end of that 8-week period, when you go back to the bank to certify how they were spent, you can show them, you know, monies coming in from the loan and how those monies were spent exactly, together with applicable payroll records, rent checks, utility payments, and other supporting documentation that you have. Okay, so all right, there we go. Okay, so there are a couple aspects of the loan forgiveness that's pretty important here, and the amount forgiven, and we'll go into how it's computed, but the amount forgiven can be affected if you have a reduction in your staff during the period of the covered period, which is the 8-week period starting on the date you receive the loan, measured against 2 other periods, and that's going to be on the next slide I'll get to in just a moment. But also, if your salaries for your full-time employee headcount is reduced by more than 25%, you could also see a reduction in the forgiveness amount. So really, those 2 things are going to play into how much can be reduced, not only confirming that you've spent the money in the way that you've intended, or that you're supposed to be spending the money, but also that you've maintained salaries at least 75% of the pre-loan amount, but also that you have staff at a level that's consistent with one of 2 periods. So looking at the forgiveness reductions in terms of the amount that can be forgiven, what the SBA will be looking at is the number of FTEs that you have during the 8-week covered period compared against the FTEs during the first 2 months of this year, or between February 15, 2019 and June 30th, 2019, which is essentially the same period last year as compared to this year. Now, one of the things to note is that to be eligible for the loan in the first place, as Levi said, you have to have 500 or fewer employees, and that's measured by counting both full-time and part-time employees. One of the differences on the loan forgiveness is that the forgiveness is based on FTEs. That's specifically out of the statute, and that's different. It's a different measurement. I read that as full-time equivalents. That's a different measurement as the number of people that you had going into the loan. So for the forgiveness part, you're going to measure FTEs during your covered period, that 8-week period, against one of these 2 periods that are mentioned on the slide. So to apply for the loan, I already mentioned this before, the SBA Form 2483, you can find it online. Every bank is requiring some different documentation, but they will require your 941s, other payroll documentation. If you have, I have clients that have employees through like a staffing agency, go to your staffing agency and get the information you need, but basically they're gonna look for payroll documentation, proof that you've been in existence before February 15th of this year, maybe your bylaws, maybe your articles of organization, maybe your operating agreement, definitely the payroll information. If funds are misused or used for an unauthorized purpose, you'll be required to repay those amounts. It could be deemed fraudulent. That's why I really make an emphasis to saying, as you receive monies, make sure you know exactly how those monies have been paid. One thing to note that I didn't mention earlier is that if the portion of the Paycheck Protection Fund loan that is not forgiven will then be termed out over a period of 2 years at 1%. I think that was mentioned on an earlier slide, but I just wanted to dovetail back in the forgiveness part against the amount that would not be forgiven. The other two pieces that I want to touch on very briefly, because I'm sure we've heard about them. One is an existing SBA program that's been expanded right now. This is the Economic Injury Disaster Loan. This is a program under the SBA. You can borrow up to $2 million, very low interest rates, term of up to 30 years. The SBA is not supposed to be looking for collateral for loans that are under $25,000, I think. Anything over that, they will look for collateral, but it's not determinative. If the loan is under $200,000, there is no personal guarantee requirement. If it's over $200,000, that there could be. This loan is not forgivable, though. This loan does need to be repaid. And you've probably also seen that there's a $10,000 grant that can be made upon your application for economic injury disaster loan. That is truly a grant, and it does not have to be repaid if you're rejected for an EIDL or if you are approved for an EIDL. It doesn't have to be repaid. And the last slide that I have is the employee retention credit, and this is a credit that can be taken if you do not qualify for the Paycheck Protection Loan Program. It's not the focus of this, but I just wanted to mention the employee retention credit for those that may not qualify for the Paycheck Protection Program. And with that, I will turn this back over, and we'll continue on with the presentation, I think, with our friend from CoBank.
Thank you, Jeff. Yes, next up is Brian Cavey with CoBank. And Brian, can you give us an update on what's happening in your shop?
Thank you, Marlis, and I want to thank you for hosting this today. Thank you to Chuck and NCFC for the great work that you're doing on behalf of your members, who are many of our customers. This has been an interesting last 10 days. CoBank started working on this program as the legislation was being finalized right before it was enacted. We've been working to streamline some internal processes because we and the other lenders in the farm credit system were made eligible as SBA lenders in the legislation, but that was all dependent on the regulatory efforts of both the SBA and our regulator, the Farm Credit Administration. Those regulations, the interim final rule from the SBA that kind of set the rules of the road, came out Wednesday night, and our regulator, the FCA, responded with some guidance Thursday morning. The final application for CoBank and other lenders who were new lenders into this program actually wasn't published until Friday afternoon, sometime after 3:30 p.m. So our ability to get approved for this process was not possible until late at the end of last week. And once that process starts with the SBA, it's a multiple step process to get that ability to access their lending portal, which they call eTran, and actually start processing these loans. We've had, we've worked on putting that procedure in place. This afternoon, while I was just getting ready for this call, the current numbers are that there's one Farm Credit Association that has been able to make a loan, and there are a couple more who have been approved by the SBA, but they're still experiencing challenges with that portal, and you can add CoBank to that list. We've been working trying to get that approval from them to get our lender identification so we can get our authorized officer linked to that, and then we can start accepting those applications and processing those loans. This has been challenging for the SBA, and part of that is a reason of scope. Last year, the SBA made $28 billion in loans, and you heard earlier this program is about 15 times that in terms of its volume, and there's been heavy demand. We had more than 100 customers by last week that had expressed interest in this before there was ever any information on our part on how we were going to be able to put that program into place. And you've seen expressions of frustration from the community banks, the big banks. There are some of the big banks that aren't even planning to process these loans. One, Wells Fargo, got in this morning and got back out again because there are serious complications coupled with tremendous demand. So we remain actively engaged with the SBA trying to get this approval produced so that we can then get these loans processed and functioning for our customers. There are also some eligibility questions out there. There are questions as to groups that are or are not eligible, and that lack of clarification is also complicating our ability to streamline this process. So we're working on it. We anticipate that, we hope that very soon we'll be able to open the application for these and start processing them, but it has been very frustrating. We've had members of Congress that have weighed in for us and for folks in the system. We've had folks from the Fed weigh in to try to get this streamlined, and folks from USDA at the request of NCFC and others. And we were told in the briefing this afternoon that the USDA hopes that these challenges with SBA will be wrapped up within a 24-hour period, but it is challenging our efforts to get this up and running with the challenges at the portal. And I would note that this afternoon, the SBA portal actually went down. My guess is probably because of the volume they're experiencing. So this is challenging, this is complicated, but we do hope that very soon we'll be able to join those banks that have been able to put these out there and get these delivered to the people, the customers that need them.
Thank you, Brian. We appreciate that real-time update. We have received several good questions, and the lawyers and Brian are going to stick around, so feel free to add questions to the queue here. I'm going to toss these first questions out to Levi and Jeff, and if they need help from our esteemed panel, they're going to weigh in too. First one I'll ask is the affiliation rules. As we all know, co-ops have lots of interesting structures, joint ventures, etc., partnerships. For the affiliation rules for the PPP program, what applies for the 50% rule? Is it owns and controls, owns or controls? How do those rules apply?
Yeah, thanks for the question. This is Levi. I can give you my thoughts on that, and then Jeff, of course, feel free to add any additional thoughts you have. So my understanding of the affiliation rules, which are quite complicated and also very facts and circumstances based, is that what they're looking for is if an affiliate has the ability to essentially control decisions of the other company. And I think under either of those circumstances, you stated the own or the control, obviously depending on the specifics of the ownership, control could be found such that affiliation would also be found. So SBA put out some additional guidance over the weekend or late Friday night on that, but I don't think it ultimately changed sort of the general rule that you look at the facts and circumstances to see if there's indication of one entity having control or being under common control with the other, such that those entities would be affiliated. And Jeff, I don't know if you have anything else to add on that particular point.
No, I read it the same way and agree with the assessment, owns or controls, but yeah, look at the facts and circumstances, absolutely.
Okay, thank you. Another question we've received a couple of times is, how do you count your employees for purposes of the PPP if you have, for instance, some part-time employees or some seasonal employees?
So this is Levi. Go ahead, Jeff.
Okay, all right, thanks. We were going to try not to do that, everyone. So, so when you're counting employees, you're counting all of your full-time and part-time employees as of the date of the application is going in. If you're more of a seasonal employer, when you're measuring the employees, you look at the period of time between June 15th, 2019, and February 15th, 2019, and June 30th, 2019, to measure your employee level during your seasonal period. On the forgiveness aspect, you're going to measure your FTEs when looking at how much can be forgiven during that same period of February to June 2019.
Okay, thank you. Can you apply for both EIDL and PPP?
The answer is yes, you can apply for both. Jeff, not to put you on the spot, but I think that it doesn't, if you have an EIDL, it affects your forgiveness for the PPP loan.
Not as long as you use the EIDL for different purposes than the paycheck loan. So if you do get both, you would make sure that you can follow the monies on the paycheck loan and make sure you're using that for payroll, rent, utilities, and interest on mortgage. And the EIDL loan would be used for, you know, other aspects of the business that are other than those 4 or 5 items that we mentioned, and then that would be okay. But that's why it's really important to be able to track your monies.
I could speak more to that. This is Ken. One issue there is if you do use the money under the IDL loan towards payroll costs, there's this requirement that you refinance that piece, so to speak, with the PPP loan. So that's an interesting little wrinkle to keep in mind.
Okay, thank you, Ken. Is there any guidance on what is considered to be necessary for purposes of applying for these programs?
This is Levi. I've not seen any guidance on that, and people have different views on what may be necessary for purposes of that certification. My thought, and again, this is just me speaking, I don't have any sort of legal basis for this because I've not seen anything from SBA on it, is that I think if I was making that certification, I'd probably want to be sure that, you know, without this money, because of the COVID-19 crisis, I would have to make certain changes to the items that are covered by this money. So without it, maybe I'm reducing employees, maybe I'm reducing salaries, maybe I can't make my mortgage payment or can't make my rental payment. Now, again, there's no official guidance on that, and I think to some extent that's a decision that each applicant will have to make. I don't know if anyone else on the panel has a different view or different thoughts on that particular certification.
This is Ken. I speak to that. I mean, it depends on the program you're speaking of. If you're talking about the EIDL, keep in mind you have to show substantial impact. So let's just put that aside. That is a different standard. Under the PPP, it's just necessary. And I think it's a really low bar, and it's a low bar for a reason. As I talk with my clients about this issue, I think in almost all cases, if they're calling me, there's an impact. There's been a few cases where we've determined perhaps maybe not, but I think just across the board throughout the country, most companies are feeling the effects of the slowdown. This is not a client, I don't believe, but the counter example I like to throw out there is I don't believe Zoom has been impacted really all that poorly by COVID-19. So companies like that actually have an industry that's thriving due to the way the economy's had to adapt. Clearly, they just don't need the loan, right? But if you do need the loan for payroll purposes, you know, I think it's a pretty low bar.
Would receiving funds under either of these programs qualify producers from receiving MFP payments or any other type of payments?
This is Levi. I'm not aware of any prohibition on that. That's not a question I've run into or particularly researched, though.
Okay.
Marlis,
Yeah, I would follow up. I would agree with that as well. There's nothing in the act that restricts that I'm aware of.
Okay. Here's another question on the timing of counting your employees. This co-op says our seasonal help expands in the spring for 2 months to get us through planting season. It puts us over the 500 employees, with the remainder of the year operating around 450. I believe you said there is a time frame in which to count those employees, and so maybe repeat that guidance again.
Sure. For the seasonal employer, the time frame is measured from February 15th, 2019 to June 30th, 2019. So I think that's gonna capture your spring period of those seasonal employees. But that's when you measure it for the qualification for the loan.
Okay. If you hire an employee before June 30th, does that employee's salary qualify under this plan?
Well, I suppose you could use the proceeds for paying that employee's salary, but for purposes of calculating the amount of the loan that you're going to be eligible for, because that's based on the prior 12 months, that employee's salary obviously won't be included, if I'm understanding the question correctly.
Right. And this is Jeff. A caveat to that is, if there was a reduction in workforce from February 15th to, I think it's late April, and the employee that you've hired back in June by June 30th brings back up the employee level, so you basically replace the employee, that would be a good thing. The statute says that employee isn't included for calculation of the loan forgiveness amount, and I'm not 100% sure what that means. It's one of these areas where there's a little bit of lack of clarity. But if we're talking about hiring back somebody who was laid off during the time period from February 15th to April 26th or so, that would definitely work in your favor.
Okay, thank you. Is the loan origination date the date the proceeds are dispersed?
That is our understanding, yes.
Okay, and are you required to compute your injury for the EIDL program?
I think the answer to that is you have to certify that you have an economic injury or loss because of the event. So from what I understand, there's no measurement, although I've heard some of the programs require a 50% loss, a reduction in profit during the time period. For the EIDL, I would have to check, but I don't think there's a specific dollar amount. You just have to be able to certify the fact that you've had an economic injury.
Okay. Can American subsidiaries of foreign companies use the PPP?
Yeah, the answer to that is yes, but for purposes of the affiliation rules, I believe the foreign entity will be counted in for purposes of counting your employees for based on those affiliation rules.
Okay.
On that point, I'd like to ask the panel, because this is an interesting point that's come up a few times. The SBA has regs that say that if you're more than wholly owned, or if you're more than 50% owned by a foreign entity, that you wouldn't qualify for a standard 7A loan. And that's one of those areas where the PPP essentially is being pushed through a program that has all of these rules and restrictions based around it for good reason, because of the purpose of the SBA up until this point was designed to just get money out to small businesses that needed it. But there's interesting wrinkles that are coming up. In one case is if you have a wholly owned American subsidiary where the parent co is a foreign entity, but you satisfy all the other requirements, how is that viewed by the SBA? I mean, if it were a traditional 7A loan, you fall out because of the 50% threshold. I'm not so sure that's the case here. So that's one area where I'm trying to track and hope we can see additional color. But I welcome my other members here on this panel to speak to that, because I think it's a very great question.
Yeah, this is Levi. I don't have any particular, other views on that. I agree that it's ambiguous at this point, and it'd be nice to get some more guidance.
All right. Is it safe to say that a single member LLC that only hires independent contractors would not be able to apply for the PPP?
I could speak to that too. That's an interesting one, right? Because they break it down. They're very clear by breaking it down and distinguishing between independent contractors and employees. You get into this weird world, and you're finding, as you dive into this, at least what I'm finding is there's a lot of companies out there that will be a regular company with quote employees, but for tax purposes, they do 1099 treatment. Now that you can question whether that's wise or not for tax purposes, but it isn't determinative whether they are then by that due to that tax treatment just de facto independent contractors. I think it's a more nuanced analysis, and so I always try to guide my clients to looking more closely at whether they're bona fide employees or bona fide independent contractors. If they're the latter, the act is designed to help them, and they are going to have access to the program as well. They just have to handle it through their own application process. I don't know if the other members on the panel here have anything to say to that or disagree to that.
No, I agree with that. I think in the guidance that came out over the weekend, there's a very clear statement that independent contractors have access to this program on their own. And it seemed to be that's where SBA was trying to push those folks to apply on their own. So I would agree with that.
Yeah, and one thing that we didn't mention earlier, maybe I think it might be on one of the slides, is for those self-employed or independent contractors, their application date is expected to be on the 10th of April. And again, once, banks may or may not be ready to start accepting those applications on the 10th. But if you're in that position, I'd reach out to your lender sooner than later.
That's a great point, actually, and I think I did a little digging in that, and the impetus behind the delay, from what I understand, and by the way, time is of the essence, as I think everyone here understands, and so the delayed start for independent contractors is kind of a head scratcher and a little unfortunate to those that are going to be filing underneath that status, but apparently it has a lot to do with the fact that especially traditional SBA lenders don't have a kind of a system in place, a vetting process really that accommodates independent contractors. It's kind of a whole new animal, if you will. And so that's been the justification from what I've heard. And I find that rather interesting as we move forward.
Okay. For an LLC, is the draw by the member owners considered to be wages?
So this is Jeff Scheer again. I will say that is a great question, and one where I'm not sure there's a definitive answer right now. I've talked to many people about this, some including a number of accounting firms that I do work with. Some have been including the member draw in the calculation of payroll costs, and some that have not. My understanding, as we've gone through this over the past week or so, is probably not to include the members draw or partners draw in the calculation of payroll costs because it is so closely tied to W-2 compensation and what's reported on the 941s. I know one organization that has members and submitted their information to a bank, and the bank came back and asked if members were included in the calculation. The answer was no, and the bank responded with a resounding good. So that's the most definitive thing I've heard on the matter from one bank. But I think I think there's a hole in the statute in that regard, and I think there was something that may have been missed. But for the time being, I'm not including those numbers in the calculation of payroll costs. But I'd like to hear what other people have to say on that too.
Yeah, that's consistent with our interpretation as well at this point.
Yeah, that's similar in the cases I'm seeing as well. I mean, to me, it's easy. I think the question you ask back to them is this true compensation where it's tied to some kind of performance that you're doing individually, i.e. more or less an employee-esque type compensation, or are you drawing on this because you're an equity holder? And a lot of times when you present it that way, I think you can get to the heart of the issue pretty quickly. And that's just something you got to be careful about.
Okay, thank you. This is a question that is causing a lot of confusion out there. The EIDL application states that agribusiness enterprises or farms are not eligible, yet the CARES Act states any business concern is eligible for loans. Is the act not clear? Does the SBA need to provide clarification?
Jeff Scheer again. I would proceed with the application based on what is in the CARES Act, which intended to expand the EIDL program. Now, just to note, the EIDL program is an existing program that is available after, I'd say similar disasters. But we haven't anything similar to this since, the 1918 flu or something. But it's available after other disasters. So I think the idea here was to expand the program, and if the CARES Act expands it as stated, I would go with that language.
Okay. Does an IRA retirement plan match qualify?
I think that's a good question. I think that the definition of payroll costs in the statute and the guidance only said payment for the provisions of employee benefits, including retirement. So in my opinion, at least, that's up for interpretation. And I'm not an employee benefits expert to see if that's something that they would typically sort of consider to be in that same category. So one of those areas where, at least from my perspective, we don't have great guidance on it, unless anyone else is seeing something differently.
Okay. Is labor supplied through a temporary employment agency considered toward your count of FTEs?
I think the answer to that is yes. I know that we have looked into that as a firm because we represent, I think, an employee agency, or one or two of them. But I think the answer is yes. I have a number of clients that lease employees out and have included them in both their employment number when making application and plan on including it with their FTEs. But that may be one of these areas where we see some additional clarification.
Thank you. If you are a sole proprietor and the business pays for living expenses such as housing, insurance, and utilities, but you don't have a salary draw, can you count these expenses as payroll?
That's not I guess I haven't thought through the specifics of that situation. Certainly if it was a business who had, some of those expenses, if it had rent and utilities and whatnot, those would be permissible uses of the loan proceeds. They wouldn't be counted for purposes of doing the calculation. And I guess one thought on those types of situations is that hopefully there will be some more guidance from SBA over the next coming days. To Jeff's point, there's not a great system for these particular types of situations under the existing SBA programs. So I'm not sure if we'll get more guidance. Jeff, I don't know if you have other views on that.
No, I was actually gonna punt on the answer too, because I think we're gonna see more guidance as this comes out over the remaining part of this week, and those sole proprietors and other self-employed individuals have an opportunity to apply. I think hopefully we'll see more clarity. No promises though.
Okay.
Yeah, I think the one thing I would add there is to be careful if you can end up getting away with using those proceeds for those purposes. They're signaling that they only want no more than 25% of the forgiveness to go towards everything that's non-payroll costs. So I think you got to be careful there because that's going to be scrutinized.
All right. You mentioned that the number of employees is based on industries. If an employer falls into two categories, farming and manufacturing, for example, can you use the category that is to your benefit?
I think that comes down to, it's based on the, what is the NAICS code. And I'm not an expert on how those codes get applied. I know they're used for various things. I think someone would have to look at whatever guidance is out there to see, if you pick one in good faith, is that sufficient? I don't think there's any, no one goes around and sort of grants those to a particular company and that is what it is. So I think if you can make an argument that you're, in a particular category and it's in good faith and you're not making a misrepresentation, I think that's okay. But like I said, I don't know the specific details of how those get determined.
Okay. Here's another question on whether federal payroll taxes are included in payroll costs. And I believe you had answered that in a prior question that federal are not included, but state taxes are. Am I correct on that?
Yeah, that is correct.
Okay. Just looking to see if there's some here that we haven't already answered. In the SBA size standards, to qualify as a small business, there are revenue caps, $1 million for most agricultural commodities. Are there any revenue caps or limitations to qualify here?
So under the CARES Act, the 500 employee test or the employee test, the language says something along the lines of the greater of 500 employees or the applicable SBA size standard based on number of employees that's applicable to your industry. So our take on that has been that there is no revenue test for purposes of qualifying for this particular program. It's solely based on the number of employees and whether that's 500 or some greater amount depending on the industry.
Right. That's the way that we've read that as well.
Okay. If you exclude H-2A employees from payroll costs and from allowable costs, would you exclude them from the FTE count as well?
I think that's a good question. I think off the cuff, I think if they weren't included when you're determining your payroll costs, I would exclude them from the FTE costs as well. But I think hopefully we're going to see additional guidance on that.
Yeah, the only thing I would add to there is that traditional SBA employee definition are employees employed on a full-time, part-time, or other basis. And I feel like other basis is a very broad term. So that's something that we've been thinking about and just keep it in the back of our mind. But again, not great guidance on that.
Okay, I think we have hit all of the questions here and we got a lot of good ones. So thank you to all of you who have submitted questions. We will make the recording of this webinar available. And I want to thank all of our speakers and those behind the scenes also answering questions. And NCFCs continue to provide guidance on the PPP as it becomes available. We also have a COVID-19 section available on our website where we list law firms and accounting and tax firms who work with our members and can provide guidance to you, including all of those firms who are represented here on the call today. So thank you very much, and everybody stay safe out there. Bye-bye.